Okay, so let's just get started. First of all, welcome to all of you, our clients and friends of the firm. I hope you're all doing well, washing your hands regularly and taking your vitamins. Before I introduce our presenters, I wanted to ask all of you again to please keep your phone lines muted throughout the call to avoid background noise. I may chime in again if we have some latecomers and have some background noise. I'm sure all of us want to hear what our presenters have to say. Thank you for joining us for lunch this Friday during what I call dynamic times. Today's discussion topic is what to do when you have a call with your tenant and or lender in an hour. For those of you that don't know me, I am Luis Flores, and I'm the managing partner of the Miami office of Saul Ewing Arnstein Allaire. I am a partner in the firm's real estate practice group. I represent developers of all types of projects with a concentration in high-end apartments, condominiums, and hotels. I also serve as Florida Counsel for Institutional Lenders, so I'm familiar with both sides of real estate transaction. My sweet spot is closing sophisticated financing structures for those developers and lenders, including construction and mezz loans. And during the last recession, I assisted developers and lenders in negotiating loan workouts and closing the sale and purchase of distressed desk assets, which I expect will pick up shortly. In short, if you need to close, you call me. One last thing before we begin, everybody. Since you are all on mute, I will be asking the presenters any questions that you may have sent in advance of today's call. If you want me to ask any questions during the program or at the end, please continue to submit your questions by using our Q&A email account. That email account is events@saul.com. Again, that email address is events with an S at saul.com, like special events, but just events@saul.com. And we're going to do our best to answer all your questions during the program. If we run out of time, we'll do our best to follow up individually with responses. Without further ado, let me introduce our presenters for today's discussion. Louis Archambault is another partner in our real estate practice group. He's a board-certified real estate expert and has over 20 years of experience representing buyers, sellers, and lenders in all aspects of residential, commercial, and industrial real estate development. Louis has significant experience in condo development, corporate structuring, institutional, non-institutional lender representation, short sales, loan workouts, and commercial leasing. Louis is an active speaker and regularly gives seminars throughout South Florida on those very same subject matters, educating thousands of real estate professionals on those topics. Louis was born and raised in Wisconsin, so he's a rare species in South Florida, as I like to say. And Louis, you can correct me if I'm wrong, but I think you're also a shareholder in the Green Bay Packers. Louis, yes. Why don't you say hello to these folks so they can all hear your voice and they can distinguish it from Javier's.
Terrific. Hello, everybody. Thank you very much for joining us today on this call.
All right. Our other presenter today is a recent addition to the Saul Ewing family. Javier Rodriguez joined us as a partner in our litigation department last November and hit the ground running by obtaining a $19.5 million verdict the first week at the firm. Javier is a seasoned commercial trial lawyer with extensive experience in a broad range of cases, including commercial disputes, creditors' rights, real estate litigation, employment cases, professional liability claims, tort cases, and loan workouts and foreclosures, which I'm sure are about to get hot. Javier has completed over 80 trials and arbitrations and has extensive appellate experience, including over 50 appellate cases that he's taken through oral argument. In addition to his bread and butter litigation practice, Javier also provides general counsel type legal services to various clients. This includes negotiating and drafting business contracts and leases, handling purchase and sale transactions, providing advice on HR employment issues, and corporate governance matters. Javier is a true Miami origin story. His father arrived from Cuba several years ago with only a quarter in his pocket. And that's a true story because I heard it from the man himself. About a few years ago, Javier took a month off from his practice to cross the Atlantic on a sailboat with a team of others. I think he chose the wrong month to go. This would have been a good month. But Javier, why don't you go ahead and say hello to everybody?
Good afternoon, everybody, and it's my pleasure to take part in the call today and to make this presentation to you and to answer any questions you may have.
Thank you, Javi.
And thank you for that introduction.
Was that true? I think you were on the sailboat, right? Is that correct?
I was on the sailboat. Now would be a good time to be doing it. That's true. It was quite an adventure.
All right, Louis, why don't you start a discussion and the rest of us online can follow along. Most of you should have received materials earlier today around 10 a.m. From our firm's marketing department. Kara Dara or Christine Laudenbacher would have been the senders. It would have been right before 10 a.m. There should have been an email with some attachments. That'll be the general outline for today's discussion. At the end of each section, we'll have a little Q&A, which again, I'll be posing the questions. And if, to the extent we have any kind of miscellaneous questions, I'll ask them at the end of the presentation. And keep sending your questions and we'll do our best to answer them all. Louis, why don't you get us started?
Sure. Thank you very much, Luis. And for today's presentation, I'm sure everyone on this call has been receiving a lot of different alerts from a lot of different sources. Our firm is no different, talking about an immediate concern related to the virus, which of course is lease issues and lender issues, either related to leasing or independently, and people being very worried about what to do when they take out their documentation and what kind of direction can they expect or prepare for in these issues, and it's coming up very quickly. So in a lot of the alerts, people would say, well, it's on a case-by-case basis, or it depends, which of course is the general advice. So we felt there was a gap there where people would need specific answers to be able to address concepts that they're going to need to understand within either their lease or their loan documents. So we put together this call, and to my knowledge, no one else is doing this at this moment because of the immediacy of the concern and the timing, to go through some specific examples and try to outline for people from the examples what would likely cover most of the terms you would be facing when you review either your lease or your loan documents on concepts such as force majeure or potential defaults or things that would need to be kept in mind when you go through the negotiation. So that's the outline here, and then of course we'll get to people's specific questions. So first on force majeure, again, that's a term that I'm sure most people, if they were not familiar with, are now very familiar with it. And I'm very pleased that Javier was able to join me in this presentation because while I deal with the negotiations and the business levels of a lot of these concerns, what the courts may or may not be saying about these provisions is very important when people are trying to understand what they have in their discussions. So turning it over to Javier. Javier, in force majeure, what would you like to tell everybody to keep in mind on a general basis for this concept?
Okay, so thank you, Louis. So the first point to keep in mind when we're talking about force majeure is that it is a purely contractual concept. If you take a look at Black's Law Dictionary, which is kind of our Bible, it defines force majeure as a contractual provision allocating the risk of loss if performance becomes impossible or impracticable, especially as a result of an event or effect that the parties could not have anticipated or controlled. So when we're talking about force majeure, we're talking about look in your contracts, probably about 2/3 of the way back is where they usually appear, and you're going to have, you know, a force majeure clause if one is in there. Not every contract has one, of course. So, and I want to approach this from kind of a two-tiered level. One is just we can talk about the legal principles and we can talk about the cases and what they say, but I also want to talk about this in a very real-world sense in terms of if I'm in court and I'm dealing with this issue, what is it I'm going to realistically expect from the judge who's hearing this case, and how is that going to play out? So I want to be able to talk about all these at both of those levels. A couple things to keep in mind. If you have a force majeure provision, it is the language of that provision that is going to control. And those clauses are narrowly construed. There's many cases that talk about that. So they're typically going to be interpreted in a narrow fashion. However, some of these clauses have broad language. In fact, some of the examples that Louis put in the materials that we sent out have kind of broad language to the extent of it where it might say, or other reason, or other causes, or things like that, to kind of be a catch-all provision. So while we're dealing with a strictly contractual provision, and it's going to be narrowly construed, if that provision has a broad catch-all, of course, that means that it's going to be interpreted in a broader fashion. It's important to keep in mind that because it's strictly based on what the parties have agreed to and what their intent is, by interpreting the language in the agreement that you can exclude rent from the application of force majeure. So if you're a landlord and your lease says, by the way, this force majeure does not apply to the obligation to pay rent, then it doesn't apply to the obligation to pay rent, period. And it's important to keep that in mind. In fact, some of the ones that Lewis included talk about that and have that exclusion, and some do not. So that's an important thing to keep in mind. And, you know, there are many examples of what does or does not constitute force majeure, but typically it's going to be something that is unexpected and is out of the control of the parties. And, you know, so if we're talking about the current environment, one could say, gee, a pandemic happens every so often. It's not completely unforeseeable, true, but it's not reasonably expected to happen, you know, during the time period of the lease or the contract in this case. And it's certainly something that the parties could not have done anything to control or to contain. So as a general matter, if you're dealing with a provision that includes pandemic or disease or anything like that in it, this is clearly going to fall within that. And I would also say to you, if you have language in your force majeure clause that says something like, and I'm going to quote from the ones that are in the materials, where it says, you know, riots, insurrection, civil commotions, war, and then this is the key language, or other reason of a like nature, not at the fault of a party, delayed in performing the act, then that sort of catch-all is going to probably apply to the current situation. There's another provision in here that says, quote, or other causes beyond the reasonable control of the borrower. Again, that sort of general catch-all provision has been interpreted by many cases in Florida to fall under a force majeure. Give you some examples, you know, a company president suffering a heart attack fell under a force majeure provision that had that sort of broad language. Excessive rain that caused delays in connection with the contract performance was considered, quote, any other condition like that. So again, when you look at your contracts, if you have that sort of broad language, you can rest assured that the current situation is one that will fall underneath that. Now, I want to stop for a minute here and go back to Lewis. Is there anything you want to discuss with respect to that before we go to some of the other topics that relate to this, Lewis?
Sure. So let's sum up force majeure, and then we can move to the others. So taking what you said into account and using our heading here. So I've got a call in an hour. I pull up these various sections, and I'm looking at them, getting ready for my call. And for the most part, I think we can assume that people are not going to have specific language related to epidemics, pandemics, biological agents, et cetera. It's not something that's most likely specifically spelled out. So if I'm getting that call, or if I'm getting prepared for that call, the general thought would be it's not going to be specifically mentioned. It's going to be covered in a general sense, which means it's going to be up to the parties to negotiate with that gray area, knowing that from a leverage standpoint, if they were in court, most likely it would not be specifically addressed if a judge wanted to say, you know, this is not a specific concern of the section, but that due to the global nature of this pandemic, some judges may be influenced to take a broader approach. Is that fair, Javier?
I think it's fair, and I think that if the clause contains any sort of a broad catch-all language toward the end, it almost certainly will be covered by the current situation. Which then brings us to the next question which is, well, how far does that go? I mean, if you have a counterparty on a contract, on a lease or whatever, that has been, let's use rent as an example, has been paying rent, is up to date on rent, and then you know, it's a restaurant and it's been shut down as a result of this pandemic by government order or otherwise, and for a period of 60 days they're closed with no income, but from one day to the next in 60 days they're up, running, and back in operation, and they missed 2 months of payments as a result of that, but are now have the ability to make payments going forward. you're going to have a hard time, assuming you have that sort of broad language where force majeure applies, you're going to have a hard time saying that that person is going to be in default under the lease and that, you have a right to, evict them or do other that sort of drastic action with respect to those missed payments. That doesn't mean that they're not going to necessarily owe the money at some point, but we're talking about a declaration of default under the lease. So I think that that would be a very tight case, okay, where you have a very clear connection between the incident that is going on right now, the pandemic, the closure of a restaurant, missing only payments during the time period that the closure was in effect. We can start taking steps removed from that very tight case. And of course, as always happens, you'll have people that will take advantage of the situation for their own benefit. But now let's say it's a business that hasn't been closed during this time, but whose business has been affected in some fashion as a result of it. Well, that becomes a little bit more attenuated. It's going to be the burden of the party asserting force majeure as a defense to make the connection, not only that this was something that was beyond their control and qualifies as a force majeure event, but directly connecting that to whatever inability to perform under the contract they have. So if it's somebody who's just saying, as a result of the pandemic, business slowed in some amount, and therefore I'm not going to make rent payments, well, that becomes a little more attenuated. And then, of course, there might be somebody who was already in default, already behind in payments when all this started, and now seeks to take advantage of that situation by not paying, for several months in the future, or even after the pandemic is over and everything goes back to normal, continues to not make payments. Those become the cases where I think courts will look less favorably on that. Where that boundary is, I don't know. It's always, there's a lot of gray in law, but as you get further and further away from that very clear, very tight case, which was my first example, it's going to become harder and harder to connect the default to the force majeure event.
Terrific. Thank you. Moving on a little bit, and I'm going to take all these together, actually, because to me, these are mostly retail lease issues as far as go dark provisions, anchor tenant, or percentage rent issues. They may apply in other sectors, but mostly it's retail. And for this discussion, I'm lumping restaurants and bars into this discussion because for the most part, a lot of those establishments are running under the same lease forms as the overall retail itself, either part of a shopping center or some sort of unified business district. So looking at these three, these concepts are also going to come into play based upon what is happening with the pandemic. Leases require for these businesses that they have to be open uninterrupted within a certain hour of time. They are linked to other businesses within the center itself, so you have provisions related to anchor tenants, because if I'm a restaurant next door to a Macy's, for example, I need that Macy's open for me to make my projections as far as income. And if they were to go dark, it obviously affects my business, and leases take that into account. Also for percentage rent, which is a very common theme that you see in a lot of retail leases, clearly no one is going to be on the same standpoint as they originally bargained for. The rent itself is going to be reduced from what the parties originally intended, and likely parties are not going to hit their breakpoints. So how that percentage rent is calculated, whether it's done on a monthly basis, whether it's done on a yearly basis, is going to come into play for a lot of these parties related to the actual cash flow that's generated. A lot of these provisions are also going to come into play very objectively because the executive orders issued by the state of Florida specify what businesses can operate, what businesses are exempt. Local governments, either the county or the city, are doing the same things related to operations of businesses, curfews that may be going into place. All of those are very important because now you have a very objective standard as to when a business simply can't operate, even if they otherwise are capable of doing so. They just can't based upon executive order. So these provisions are going to come into play very quickly. Javier, from again, on a litigation standpoint, what would be your thoughts related to these certain provisions?
Well, again, we've been talking about rent payment, but they really apply to all of the provisions in a lease where we're talking about the party's performance. So with respect to acts of government, it is a well-recognized excuse for non-performance if you're relying on a government action. In this case, for example, restaurant closures. There's no way that the restaurants that have closed as a result of government orders in this case are going to be held to have violated a provision in a lease that says they have to be open certain hours. That's going to be an absolute defense to those provisions. And remember, we haven't talked about this, but at some point we can go to that, which is that force majeure is a contractual provision, and it's strictly that. But there are other similar types of defenses that are common law defenses that a party can raise even if there is no force majeure provision in the lease. And an act of government is going to be one of those, as well as things like impossibility of performance, where the Government Act would fall under that, frustration of purpose, commercial impracticability, and things like that. And we can talk about those in a little more detail. The burden there on the party asserting that defense is a little higher. They're a little bit harder to connect all the dots and to prove than would be
I think we just lost Javier. Louis, are you still there?
Yes. Okay, so I'll continue on. And then you can jump in here for a second. Javier? Okay. So moving on to the next section, and then I'll bring in Javier to finish his thought and add any levity if he has it. Challenges for different sectors. So even though we're talking about leasing, obviously each sector is going to be affected in a very different way based on the pandemic. At one end of the spectrum, you have industrial, where I don't even know if industrial is going to be much affected at all. Maybe from an operations standpoint, if people get sick, or as far as how they manage their facilities, but a lot of either trucking or shipping is right now essential businesses, and their business as usual. And then obviously on the other end, you've got retail and multifamily, where their businesses are greatly affected by what's
sorry, I'm back on the line. For some reason, my call dropped, so I apologize.
Sure, no problem. So Javier, and then I'll turn it back over to you. We're just on the sector discussion here. Okay. And then on the end of that is multifamily, which is going to be highly regulated and will have its very specific requirements. I know Fannie Mae, Freddie Mac has announced that they're going to allow for some loan abatements. You'll have federal governments or state governments that may institute prohibitions on evictions or collections procedures. So multifamily is going to have a lot of regulations here that are going to be different from the other industries. And then office, clearly, office is affected where you can't get to your office. But as soon as restrictions are lifted, there's nothing fundamentally wrong with the office itself. We can all get back to work. So the different sectors will be treated differently depending upon what the pandemic and what's specifically at stake in the facts. So Javier, I'll turn it back over to you related to the sectors if you had any thoughts on that from a litigation perspective, and then we can go to Q&A.
I'm sorry, since I fell off the call, I didn't get the full point you were making, which sector are you referring to now?
Sure. So we're talking about office, retail, industrial, multifamily, related to how that might be treated differently from the courts. It sounds like from your prior answer, it would be the courts would just have to determine that on a fact-by-fact basis.
I believe so. And again, I think the important thing is how big is the hole that the party is that's trying to get through. What are they trying to get through that hole? So in other words, if we're talking about a default over a very limited period of time that coincides with all of the current events happening and all of the government orders and so forth, that's one thing. If you have somebody who's trying to go well outside the scope of that and yet rely on this defense as as grounds for non-performance, they're going to have a harder time doing that. I think you will have sympathetic judges to these claims if they're narrow and focused. I think if somebody's trying to take advantage of it to excuse a more significant default or non-performance under a contract, I think the judges will be skeptical of that.
Right. Luis, have we gotten some questions that people want to have answered on leasing?
Yeah, well, let me dive in here because, you know, I know the scope of this conversation is really, we've been talking about landlord-tenant, but Javier and Luis, this force majeure conversation goes across the board, right? Whether it's for a construction contract, a lease contract, a purchase agreement, this comes down to whatever force majeure provision you have in your contract. Isn't that the case? Whether it's a landlord-tenant relationship, a builder-owner relationship, a seller-purchaser relationship.
Yes,
absolutely. Any agreement that has a force majeure provision in it.
So you're applying the same type of analysis. And what I was hearing from you guys, some of my clients have called and say, well, wait a second, let's assume they don't have a force majeure provision. Am I hearing you correctly, Javier, that if you don't have a force majeure provision, you're kind of SOL, right? You don't, it's a contractual thing. If you don't have it in your contract, you said there was maybe some common law defenses.
Yeah, so force majeure is purely contractual. So, and it's going to be controlled by the language and the clause in your contract. If you don't have a force majeure provision, then you can't rely on that as a defense to non-performance. There are some common law doctrines. So, for example, frustration of purpose is something that a party could rely on, and that excuses performance when there is a supervening event that fundamentally changes the nature of the contract and the value of the performance is significantly impaired or destroyed. So that's a defense that is available that somebody could try to assert. Impossibility of performance is somewhat related to that, and it excuses a party's performance where the purposes for which the contract was made have on one side become impossible to perform. You know, so the typical case of a, you know, that somebody might use as an example is you hire somebody to, you know, do some work on your boat, let's say refurbish a boat, and the boat sinks. Well, the boat's no longer there. The contract becomes impossible to perform. That's an extreme example, but it's available. Whether it could be used into the current situation is doubtful, but it's going to be there. And this is an important point. I'm glad you raised, Louis, because if you're a party seeking to enforce a contract, let's say you're a lender and you're trying to enforce your contract against a defaulting party, given the current scenario, you can expect that good lawyers on the other side will try to use force majeure, and if force majeure is not available, use some of these other analogous common law doctrines, which, again, the burden on these common law doctrine is going to be higher for the party asserting that as a defense. They're going to use these to their benefit, and they may get to a point where, with appropriate affidavits and so forth, can create at least an issue that has to be resolved at trial. And they may be successful in defeating your motions for summary judgment, which, you know, every lender that's got to resort to the court system to enforce their documents wants to get the matter resolved quickly. That's always our goal, to get in, prepare the case, get in front of a judge on a summary judgment motion, and succeed so that we get a judgment quickly and efficiently. But if now we're having to deal with these defenses, and you may have a situation where a judge looks at it and says, you know, and they may not carry the day, but it's an issue. We're going to have to go to trial on that and see how that shakes out. It could significantly delay, you know, you going from A to Z on your case. So that's something to just be aware of. And I anticipate that even if they're not ultimately successful in using these common law doctrines, that they will be utilized.
Thank you, Javier. Now, just shifting back a second now, because Louis has some sample force majeure provisions in his outline, and we talked about how some of the catch-alls may apply, because we don't normally have a reference to pandemics in some of these provisions, but we normally have some kind of or other situation or a similar situations kind of language. Is the idea then, if you have a decent force majeure provision, is the idea then that you're fully excused from performance? And if so, when does it start and when does it stop? Are we looking at the executive orders as triggering that clock for our respective jurisdictions?
Well, the answer to that question is no. You're not permanently excused from performance. What it does is it gives you a period of time during which performance is excused as a result of the force majeure situation. So using the example of a restaurant, like I did earlier, because that's an easy one. All the restaurants have been required to close for now. It's been, what, a week and a half or so? But let's assume that goes on for 30 days. That could be an excuse to performance under that contract for the period of time that they're required to close. It would not excuse it into the future beyond that. And that's something that the party that's using the force majeure clause has to not only prove the force majeure event, but also has to prove that they've been affected by the force majeure event to the extent that they've been unable to perform under the contract. And then, so I think that once these orders are lifted and restaurants are in operation again, that would no longer apply. So it creates a window during the event, which is a fact issue. How long is that going on for? During which it would excuse performance.
Thank you, Javier. A different question now, a little more virus specific. You're a landlord, you have a tenant, whether commercial or residential. The tenant has informed you that, let's take a commercial example to begin with, right? The tenant's informed you that one of its employees has tested positive for the virus. What rights does the landlord have to bar the tenant from occupying the space? Because they have some obligations, don't they, to the rest of their tenants to keep the property safe and healthy?
Yes, this is Louis. I'll jump in on this one. And this is a very important issue because it's an immediate health concern that I know that we all have if we're either managing properties or if we're a landlord for properties. And within the use section of your lease, there's generally a very broad section where we talk about how the tenant can use the property or how they can use the common areas of the property. And within that section is going to be broad language that allows for the landlord, because it's their duty and their right, to control their common area spaces and to control the property that they own in a way where their tenants are not either causing harm, injury, or a threat to any of the other tenants within the building. So that power will give a landlord the ability to control not only the overall space, but the tenant's space individually. What I would also encourage landlords to do is OSHA has a virus guideline book. It's a very, I'd say a 20-page PDF that you can find on the OSHA website where they give specific guidelines on how you can manage your workspaces and to protect from the virus and dealing with these issues. I would encourage, if you're a landlord, to send that to your tenants so that they understand what their guidelines are and what they should be doing. And if you're aware of them not following those guidelines, then you have general power in the use section of your lease, most likely, to force that tenant to abide by the OSHA guidelines to protect themselves and to protect other people in the building. And you can use those similar guidelines related to your common space. And I would encourage landlords to be very aggressive with that because, again, talking to Javier about some of the generalities of the court, I would rather be defending one person's lawsuit saying that they were unfairly treated related to the guidelines than a larger lawsuit by all of your tenants or individuals that somehow they were put into a threat by one of the tenants or that somebody caught the virus and was damaged as a result of a tenant not abiding by either quarantine rules or rules related to being safe under the guidelines.
So how does that change, Louis, then when we switch over, let's say, to a multifamily apartment complex where there's a tenant in a residence that has tested positive and is self-quarantining in their unit? What should a landlord be doing? What confidentiality measures do they need to be following regarding personal, information regarding their tenants, and what should they be doing?
Right. So this is actually a discussion that's been going on the condominium side. So I'll address it from a condominium perspective because from an apartment perspective, I wouldn't look at that any different than commercial landlords as far as securing common area space and giving notices to each of the individual tenants on how they need to conduct themselves. But within the condominium structure, there's actually a section of 718 that comes into play related to states of emergency. The advice that we've been giving for associations is they do have the right under that to do what they need to do to protect their building and their residents. And that varies based on condominiums. So some condominiums that are more broad-based in their residents maybe would be restricting common area access, being more strict about who enters and exits the premises, and no access to common areas such as the pool that would otherwise be covered under, shelter at home orders or things of that nature. But there are also buildings that have more senior citizens where they've restricted all access in and out related to the building for the good of their residents. So it's somewhat on a case-by-case basis, but the landlord in either an apartment or if you're dealing with a condominium, they do have obligations here. And if a resident is to test positive, the general advice at the moment is you do not have to identify that specific tenant, but you need to tell them they need to self-quarantine, and you may decide to tell the building that someone in the building has tested positive, but you wouldn't specifically identify them. If that individual refuses to self-quarantine, then you have a different issue where the police could potentially get involved because then they're being a danger to everybody in the building and they need to self-quarantine or there's consequences. And I think that the way that the police have been looking at that issue of people refusing to self-quarantine has become more and more official in the way that they will restrain an individual to make sure that they're not a danger to other people. And I would expect that to continue as the virus continues to, at least for now, continue on its trend upwards as far as those affected.
And since we're just touching a little bit on residential leases, I'm not sure if most residential leases have force majeure provisions, but if they do, then theoretically, would those tenants be able to use a force majeure defense to avoid paying rent until things normalize again, or what's your thought on that? Or can you,
right?
Barring any government action, you could evict those tenants, couldn't you?
There will be government action. I think that's the best way to understand that is there absolutely will be action because, and just from a press standpoint, you don't want to be the one that puts somebody out on the street. But because of the nature of this pandemic, I'm expecting that there will be restrictions such as what was already instituted in the city of New York City, that you cannot evict people during this time. And that's why I think multifamily has to be addressed differently, because there will be separate, discrete issues to multifamily that you won't see on the commercial side.
Let me chime in on this, that even if you have a force majeure provision in a residential lease, again, if you do, then it's going to be strictly construed in accordance with whatever it says. But typically, difficult economic circumstances do not qualify as force majeure unless it's something really crazy out there. So, just to give you an example, people might lose their jobs all the time unrelated to the pandemic. So if somebody lost their job and is unable to pay rent, that's probably not going to fall under the force majeure provision, but it might be covered, as Louis said, by government decrees, so to speak, suspending, eviction for a period of time. It doesn't mean they wouldn't know the rent. It would just mean that you can't evict them during that time period.
Okay, one last question, guys, before we shift over to the other subject. So, Javier, this one's for you. Now, if you're going to bring a defense of force majeure, you mentioned some common law defense. If you don't want to perform, or do you have to pick one of those options, or you can throw all of them in your defense action, right? You could say, I have force majeure defenses, I've got common law defenses, I got impossibility. You can pick and choose as you please if you're trying to avoid performing under a contract.
Absolutely, and in the typical case, that's what the party would do. It would raise all of these: force majeure if a provision is in the contract, impossibility of performance, commercial frustration, things like that. Those would all be raised as separate and distinct defenses, some of which may be easier to prove than others. But yes, I would expect you would see all of those.
And that goes across the board: landlord-tenant, lease arrangements, construction contracts, purchase agreements, contracts, period.
These are general contractual principles. They would apply to any contract. So yes.
Got it. Thank you, guys. All right, so Louis, why don't you take the baton from here and go on to our second heading for the day.
Sure. And given time constraints, I'm going to deal with both of these lender headings at once, so we can try to get to Q&A. So we wanted to point out some things, and again, this is lease related, but they could apply more broadly related to lender concerns. And this is something to keep in mind when you're having the negotiations is, first of all, loan agreements within lender documentation or landlord documentation with their lender is going to provide that if you have any threatened or pending litigation, that you need to notify the lender. So this came up in a specific question that we had in the firm where a tenant was contacting their landlord and simply telling them, look, for next month, I'm not paying rent. So do what you have to do. And the discussion was, how do you address that? And one of the comments that we wanted to make clear was that in dealing with that tenant, you want to be broad-based in how you deal with them and not necessarily threaten them with what's called anticipatory repudiation or breach, that they're already in breach of the lease. Because once you classify that action or the negotiation as a breach, you're going to have disclosure requirements with your lender. You're going to have disclosure requirements with your investors. You're going to have marketability concerns in the future when you have an affidavit you have to sign related to any potential litigation that you have with the property. All of those are now going to come into play because you classified your negotiation as litigation. However, if you reply instead that I received your correspondence, we understand the difficulties that everybody's facing as a result of the virus, give me a call and let's have a discussion about what we can do related to your situation, and that I will take your letter to be a request for discussion. And then have the discussion and see what you can do. There's a good chance that action would not be classified as pre-litigation. It's more of just simply a loan modification or a lease modification. So you take yourself out of the bucket of being either threatened or pre-litigation. And I think that that's important from a business level as to where that would have potential ramifications. And the second part of this is most loan agreements are going to have requirements that if you're doing a lease modification, the lender is going to have to consent or approve that modification. So if you're dealing in a building where you have a lot of leases that you're potentially trying to negotiate, or you're considering doing some sort of blanket abatement with your tenants as an offer to make sure things are taken care of for at least the next 2 to 3 months, that's a discussion to have with the lender so that you can work out ahead of time what your proposal would be as far as the lender's consent. And that way you approach your tenants knowing that the lender has already approved the direction you're going to take. So it's an important step that, when the lender's calling in an hour, to keep in mind what you're going to do in the discussion you're going to have so you can set yourself up properly with your tenants. And then, Javier, I turn it back over to you if you want to add anything on these concepts.
No, I agree. I agree with what you're saying. There's a way to deal with this, with these on the front end. There's many ways to skin the cat, so to speak, that you can deal with a counterparty that is having some difficulty as a result of the current circumstances, where you're not giving up your rights, but you're finding a flexible solution. If there's good faith on both sides, I'm sure that can be found. I think much of what will be happening related to this in the coming weeks and months will be along the lines of those collaborative type of scenarios where parties come to some sort of a workout or agreement that is reasonable and makes sense to everybody without kicking it down the road. To the extent you have people that try to take advantage of the situation to further their financial position and not perform under a contract, then I think you're going to have to take a harder stance with people like that. And I think that we'll have more success in the courts with those.
Great, thank you. Luis, a question and answer. Can we answer some people's questions?
Sure. I mean, and a lot of these kind of go to what Javier was just saying. Do you expect lenders to be less stringent on operational defaults given the current climate? Pardon me. For example, will they allow landlords to make decisions quickly to save the integrity of the properties?
Sure, I'll jump in real quickly.
Silence.
What we saw in the right. Well, yeah, because I think Javier already added his input on this issue.
Right.
My general thought is what we saw at the end of the 2000s, and a lot of the lessons we learned from the Great Recession will apply here, specifically towards lender and lender workouts. And that is, if the lender has one default, that's a problem of the borrower. If the lender has 100 defaults all at once, that's a problem of the lender. And the lenders are going to be eager to try to work through this as best they can, because if they get overwhelmed by defaults, they are then going to be in distress versus if they simply were proactive and worked this out with their borrowers.
And so how do you think the lenders will be memorializing those? What might the scope of those documents look like? And you and I have talked about modification versus forbearance. I think you and I have agreed that it's probably better for both parties that they look more like loan modification agreements, because if you do a forbearance agreement, that looks more like there was a default and neither party really wants to have a history of, hey, I had a default on this loan, whether you're the borrower or the lender. What do you think, assuming they take the form of more of loan modifications or forbearance agreements, really, just talking about titles here of documents, what might those agreements capture? What might be some of those terms going forward?
Sure. So, and I'll jump in. So what we saw a lot, and this goes back again to the Great Recession. At that time, I was doing a lot of work for loan workouts, forbearance agreements, deed in lieu of foreclosure, dealing with loss mitigation issues with the FDIC after banks had been taken over and were vetting their assets. And what a lot of them would do is take their existing loan and bifurcate it. And the benefit of that was they were able to put the main loan in a conforming status, which was very important for their servicing requirements, which was very important for their delinquency rates and percentages. So from an underwriting perspective, most of the loan is able to be salvaged under their lender guidelines. And then you would take either payments due or interest due within the period of the potential default and create a separate note, usually a demand note, that would be payable at the end of the term, so that you would be able to do a modification in that respect. And then if the borrower is able to pay back that note, or if they're able to refinance the demand note, that is something that they could do in the future. So it was a nice way to be able to have the lender get everything as conforming and get it out of the ledger of delinquency that they could, and while still being able to deal with the crisis.
And it also comes down to creativity too, right? To some degree, the most important thing for any real estate property is to carry the insurance and to pay the real estate taxes. So at the very least, you want to be paying those things to carry the property and maintain it insured and with no liens. And so I think there'd also be some conversations about waiving escrows or applying monies in escrow towards certain payments, or at least that conversation will start taking place to the extent there's no as much cash coming through that would normally be coming through.
Yeah, absolutely.
Correct.
Let me jump in on that one. So, for example, you can, if you're a landlord and you're holding monies in escrow for a tenant and they've missed 2 months of payments, and of course you still have your obligations with respect to the building. One of the ways to do that is to say, okay, we're going to take those monies out of the escrow with an agreement of the tenant. We're going to take those payments out of the escrow and then give the tenant a period of time to replenish the escrow. That can be done, monthly in small amounts over the course of a year, or whatever, depending on how much time remains on the term of the lease. So you can be creative in ways. I would say don't give up on the amounts that are due during this period of uncertainty that might be covered by force majeure, but rather look for ways to, creative ways to still be able to retain and obtain that cash flow, but at the same time, give the tenant an opportunity to pay that in over time.
Right. The only thing I would add to that, though, is, again, the lender is going to do what they can, but they also can't take some action that's going to put them in a delinquency situation with either their underwriting or with the loan documents. So particularly with CMBS loans or conduit loans where you have a cash account deposit agreement or some sort of operational agreement that when there's a default, the lender has the right to seize the account related to the default. They're going to want to take an action where that doesn't occur. Because, again, what we're trying to do is work with a borrower to extend out terms to be understanding, but also not trigger delinquencies. And that's the goal.
And since you just mentioned CMBS very in passing there, Louis, I think obviously the nature of these conversations is going to be different based upon who your lender is. A private lender versus institutional lender versus a loan that's now in CMBS. I would think that the CMBS loans are probably going to be the most challenging, aren't they, to negotiate workouts and any kind of loan modifications because we have more layers there.
Yes, but from a different perspective. I mean, all lenders, again, are going to have underwriting guidelines. They're going to have requirements for delinquencies, deposit requirements. All of those things will come into play. But I was very happy to hear earlier in the week when the Fed announced that they would be a lender of last resort related to the CMBS markets and also with other lenders that would filter down to the community level. That's very important because what you saw in the Great Recession was, you know, a $10 trillion CMBS industry went to zero because of the amount of delinquencies and the system simply just not able to keep up with the liquidity portion of this. And the fact that the Fed said that they would jump in as a backstop is very important for that marketplace so people have certainty that the system itself will not collapse like it did the last time. So I was very happy to hear that because you will then have a lender of last resort for SBA loans. You'll have a lender of last resort as banks have to float different loans with the Fed, and you're also going to have something in the backstop for CMBS. So I thought that was a very welcome announcement.
And I know we're running a little bit out of time because I do want to end this at 1 hour on the nose. We talked a little bit last night, and we don't have it really on the headings, Javier and Louis. Let's talk. Can you guys maybe talk a little bit about business interruption insurance? That's something people are looking at a lot nowadays.
Yeah, so this is Javier. I'll jump in first on that. I think that one of the first things that everybody can do during this time period is dust off your policy and take a look at the business interruption coverage. Of course, this is a fact by fact, case by case analysis because every policy is going to be different. I can talk generalities with respect to some of those, but it goes without saying that whatever coverage you have is going to be controlled by the specific language in your policy and what's included or excluded from that. But as a general rule, typically the business interruption is covering your losses as a result of, if it's a connection with your property insurance, your inability to access your property. So you can see in some instances where it might be covered again through government. In this case, there's not a hurricane that destroyed your property. It was government saying you cannot operate during that time period. And that's a good argument that under that scenario that would apply, but it's not going to apply to every business. It's not going to apply to every business owner. It's not going to apply to every building owner. The other thing to keep in mind is those clauses are very, again, narrowly construed. Although if there is any ambiguity in it, it's going to always be interpreted in favor of the insured and against the insurer. So that's my 35,000 foot view. My general comments with respect to business interruption insurance. And of course, since you're talking about lost profits, track record is important. Any sort of the typical lost profits analysis you would deal with in a business case applies here as well. And courts will not award lost profits if they're speculative in any way. So it's got to be something that is not only can be proven, mathematically or actuarially, whatever, but also that you've got a track record of it. You have to be able to show years of that in order to really justify projecting into the future what your profits would have been.
Right. This
Louis,
is a great answer. I really have nothing to add. That was a terrific answer.
Right. I was going to ask you something different, Louis, since you and I were both active in the loan workout 10 years ago now. What provisions would you tell your clients to look at today, whether lenders or borrowers? Where would you go straight away in the loan agreement given the current pandemic?
I would be calling the lender and having just a general discussion. There's obviously a lot of flexibility and discretion that's built into these loan documents in favor of the lender, so that the lender can do what it needs to within reason to be able to work through different issues. In a lot of ways, the parties that contacted the lender and just had an honest discussion to try to work through some sort of a workout or forbearance got along very well. The lenders were very receptive to that. It was the borrowers that either completely disappeared or told them, you know what, come get me. Those were the ones that created a lot of issues, because then at that point, you had to kick in provisions such as default interest. You had to chase them down. And inevitably, when they got their lawsuit for foreclosure or for collection, they contacted you to do the workout anyway. And then at that point, the clock had been riding for a while. So it's really just have an honest discussion with the lender about what you can do in your particular situation. So at least you have each other's contact information. You can start the discussion of what you're going to need for your business, and you can start to accumulate the paperwork that you're going to need in order for the lender to be able to approve whatever it is that you do. Because from their perspective as well, and then this was something Javier mentioned, they can't just jump into a lot of workouts without something in their files related to what they're doing from a workout perspective, and the potential hardship of their tenants. The same thing, even if it's free and clear, you're going to have investors. If it's a REIT, if it's just a group of individuals that own a building, they're all going to need something in their file to justify that they did the workout. So being proactive with the lender is definitely the best policy.
Yeah, and I would add to that, consistent with what Louis just said, start putting together your case, so to speak. Start by, documenting exactly how you are being financially affected by this. If it's because you have tenants that aren't paying, if it's because your business was shut down, et cetera, start preparing that information for when you do sit down with a lender. You've got it all, for them, and that would justify whatever relief you're seeking from them.
Thank you, Javier. Javier and Louis, do you want to add anything before I give some closing remarks?
Go ahead. No, I think I've been talking enough. I think I'm good. Unless you got a question, I'm good.
I'm good as well, but I do want to thank everybody for joining the call. It was really great that we were all able to get together for here, and I hope that everyone found this informative.
Absolutely. Javier and Louis, listen, I really want to thank you for your time and effort you put in today's call. I know that if we were in our new event space at 701 Brickell, our new offices, there'd be a big round of applause at this point. Everybody's been forced to be on mute. So Louis and Javier, for your purposes, just close your eyes and imagine a standing ovation in front of you. So that's all I can offer you at this point. If you have any follow-up questions to our guests on the call today, please reach out to myself, Luis Flores, Louis Archambault, or Javier Rodriguez, and we'll do our best to respond. I'm hoping everybody has a nice weekend, and that brings us to a close for our presentation. And thank you, everybody, for joining us.
Thanks again, everyone.
Bye, guys.
Good afternoon, everybody, and be safe.